want to bring back in my guest quickly here, criminal defense attorney John Mobley. John, the prosecution is putting together a very straightforward, very solid, very strong case with a lot of gruesome testimony. This was a grisly murder. I just don't see any way out here for the defense at all.
Well, kind of disagree with you on that one, all right?
Okay.
And I just think you really kind of got to understand the significance of the blood and what it means and what it doesn't mean, okay? First thing is this. As many times as a victim was stabbed in this case, you got to get that expert to admit that there should have been a ton of blood that came out forward on whoever stabbed her. That person should have been covered with blood, splattered with blood, hair, face, clothes, shoes, everything, okay? So with respect to the blood that was found in this case, what the defense wants to try to argue, hopefully, is that, number one, there should have been a significantly greater amount of blood on the defendant, which there was not. And number two, where was the blood located? And when I say that, the blood on his clothing, was it located on the front of his shirt and the top of his shoes, which is consistent with him being present and in front of the victim or being a participant in the stabbing? Or is it blood on the back of his shirt and the bottom of his shoes, which is more consistent with him having, a contact with the blood because it was inside the car? If it's on the car seat and he sits on the car, gets on the back of his shirt, if it's on the car floor mat and it's on the bottom of his shoes, that's a big difference than being covered with blood, because he should have been covered with blood. They should have found blood in his hair. They should have found blood all over him, and he was actually involved and up close with the murder.
No question about it. And I agree with you to a certain extent. We're out of time right now, but we're going to discuss this more in just a little bit, John, so stand by. The evidence continues to pile up in the mistaken ride murder trial. So coming up next, a crime scene investigator takes us through it piece by piece in our testimony of the day. And we'll get back to John about some of those issues. So keep it right here on Point TV. Again, just want to remind the viewers here quickly as I bring back in criminal defense attorney John Mobley that they're saying suspected blood because that particular witness did not actually test the blood. They'll bring in a blood expert to come in and tell you whether that was blood or not, and probably tomorrow they'll do that. All right, John, I want to get back to what we were talking about the placement of the blood. That's not really where the defense went in cross-examination. One of the areas of focus is the fact that pictures were taken of the defendant a day after the event when he was arrested, and there were no scratches, nothing on him in that sense. And they're going more in that direction. I guess the placement of the blood was not something that was advantageous to their case. But where they're going is, if there had been this epic battle with all these stab wounds, and clearly when you look at some of the markings on the body of the victim, it appeared to be a really vicious fight in the backseat of that car. There were no scratches or anything on him, and they're really, I think, putting all their chips into that basket.
Yeah, I kind of think that's a mistake. I don't think anyone is going to anticipate that a 20-year-old or a young 20-something female is going to put up a big fight against a male who's stabbing her to death. So I think they're kind of going down the wrong road on that. I would not agree with that defense at all. I think they really need to kind of focus on the evidence, from the crime scene, the blood that's inconsistent with him being present from that standpoint. I think that's a greater indicator of that. And obviously there's still the blood that's on the clothes, on the items in the trash can in his house, but that's different from blood being on his person.
Yeah, I mean, that's partially true. But again, when he was arrested, it was a day later, so you wouldn't expect to find blood on his person. Now, they've matched up the clothes that they found in that garbage can. They've had testimony from his girlfriend that that's what he was wearing when he showed up and left her house as well. So we have that connection. And here's the problem. Even with that, now I understand what you're saying. If you can maybe show that the blood wasn't in one location, it was in another location, but all of his actions after, the cover-up, his trying to sell the phone, the fact that this was such a brutal murder, and they have this guy doing the cleanup, even if you don't really buy or they're able to prove that he was actually in that car, they have him in the car about an hour and a half before he picks her up, all those things, I just can't see the placement of blood on clothing being enough to convince a jury not to convict him.
Well, I think, I've always kind of believed in this case, the strategy is not to go for a straight not guilty. I think there's just too much that ties him to some involvement. I think a better strategy, based on the evidence, is that he had knowledge of the crime and maybe perhaps was involved in covering up the crime after it happened, and he's not guilty of murder, he's guilty of something such as accessory after the fact or a misprision of felony, which means you have knowledge of the crime and don't report it. I've always thought that was a better strategy because he clearly has some connection with something that happened, but they haven't really presented a clear theory as to what their defense is, which is why I got a real problem with what they're doing in this case, because I'm not really sure I'm following what kind of angle they have regarding why the jury should find him not guilty of murder.
Exactly. They're not establishing anything, any kind of story in their cross-examinations. I think that's one of the things that I've noticed. But according to what you're saying, I think one of the big problems is if you're going to do that, you really have to have him take the stand, wouldn't you?
He's got to do that. He's got to take the stand. I mean, I think I would focus on two things. Number one, they got to explain the cell phone ping. I mean, that is, I think, probably more damning than the physical evidence because it puts him with her all the time. They've got to explain that. They briefly touched upon that when they asked about some people having two cell phones. I think what they need to be able to do is, and he's got to testify and have witnesses to back him up, that, hey, he carries two different cell phones, you know, and he can demonstrate through witnesses, a phone record, that that's not the only cell phone that he has, and the other one's at a different location. So that would explain someone else having a cell phone. But they've got to really, I think, put up some theory that he was not involved in the murder, he had knowledge of something that happened, and he had tried to cover it up. But they need to present that theory so people can kind of start, or the juries rather, can kind of start following it and start kind of going down that road and seeing where they're going, because the questions they're asking really aren't going anywhere. I mean, they're just not getting the job done. They kind of got to present that theory and start asking questions to support that theory along the way during the course of the trial.
Yep, couldn't agree more, John. Couldn't agree more. All right, stand by. We're going to take a quick break now. Coming up, more on the hearings today in the killing of Ahmaud Arbery case, including the defense's contention that Arbery was committing a carjacking. We'll have that and more coming up next right here on Court TV, your front row seat to justice.